Hello, everyone, and welcome to Identifying and Responding to the Torture of Children, a four-part series for healthcare professionals, presented by the International Society for the Prevention of Child Abuse and Neglect, the International Society for Social Pediatrics and Child Health, the University of Florida College of Medicine, and the University of California, San Francisco's Health and Human Rights Initiative. We thank you so much for being with us today and appreciate everything you're doing to help and protect children. Now I would like to turn it over to Dr. Jeffrey Goldhagen, President of ISOP and Professor of Pediatrics and Chief of the Division of Community and Societal Pediatrics at the University of Florida, Jacksonville. Jeff, over to you.
Well, thank you, Heather, and thank you all for joining us today. The fact that we're even here today reflects a basic global failure on our part as it relates to fulfilling the rights of children. Rights that are articulated in the UN Convention on the Rights of the Child. It is clear that torture should not happen to anybody, but in particular, it should not happen to children. And yet we're here today talking about how we can identify and respond to the torture of children. The intent of this four-session seminar is not to turn us all into global experts on torture, but it is meant to begin to introduce us to the fact that, in fact, torture happens. It's happening globally today. It's happening on the southern border of the United States, and that children everywhere around the world are at risk for torture. So it's not meant to turn us into experts, but it is meant to turn us into advocates and to transform us into advocates that can work together in the future to address this critical issue, and to function, perhaps, if we are successful with this four-part seminar, as a global group that can organize to advocate for preventing torture in children globally. Towards this end, as you can see in the slide here, we've worked really hard to put together a four-part session series of seminars that will address this issue. Today, we're going to be talking about the infrastructure and the global context for torture, and in a moment I'll introduce our speakers. We have four renowned speakers that will be joining us. The middle two sessions are meant to really get down to the nitty-gritty, so to speak, as it relates to actual identification of torture in children, both from the physical standpoint as well as from the mental health standpoint. And those two sessions will be focused essentially on providers who are out in the field, who are seeing these children in multiple different venues, and to give them some sense as to what to look for and how to report it. The last session is a session that will include panelists from around the world, in particular panelists who represent different organizations. And it's meant to be, in a sense, a mini strategic planning session where we can begin to talk about how we move this agenda forward. And so I'm going to end here, but before I do, I want to thank you all for your participation and in advance for your involvement in helping us put together this global working group for leadership in this arena and to serve as advocates to address these critical issues. You know, there's a famous saying, if not us, then who? If not now, then when? As these issues are unfolding as we speak here today, there is no time to waste to begin to address these critical issues. And again, I want to thank you all for joining us now and for participating in the future as we move forward with this agenda. As Heather mentioned, this is a collaboration between ISCAN, ISOP, the University of Florida, and the University of California. And to all of those who have worked hard over the last year or so in putting this seminar series together, I want to thank them. In particular, I want to thank Heather Hine and Ray K. Watley for their efforts and their work in helping to organize this seminar series. So, as we move forward, Heather, could you put the next slide up? Want to introduce today's speakers. The first speaker today will be Colleen Kivlahan. And Colleen, I met for the first time a couple years ago when ISOP had its annual meeting in Beirut, which was in fact the genesis for this meeting. She is the Senior Director of Health Systems Innovation at the American Association of Medical Colleges and serves as a consultant to Physicians for Human Rights and is in fact today actually in Turkey. We're not sure she's going to be able to join us, conducting a week-long seminar series with colleagues, physicians from Syria and the region to address these issues. She's done more than 200 torture evaluations. And so, Colleen comes to us not only to present the theoretical basis of what we'll be talking about, but also she has extensive experience in actually caring for torture victims. And she is a family medicine specialist and professor of family medicine at the University of San Francisco. Renate will be doing our second presentation. Renate Winter, and I've had the pleasure of working and getting to know Renate over the past couple years. She is a renowned jurist. She's an Austrian judge to the Special Court, was an Austrian judge or is an Austrian judge to the Special Court for Sierra Leone, and an expert on family law, juvenile justice systems, women's justice issues, and child labor. She was a member, or she was actually the head of the UN Commission, Commission on the Rights of Children, or Committee on the Rights of the Children. She served as a judge at the Vienna Youth Court since 1981. She was an international judge of the Supreme Court of Kosovo as part of the UN Interim Civilian Administration, and is the former president of the International Association of Youth and Family Court Judges. And she's chaired numerous, perhaps innumerable, conferences on juvenile justice and gender-related justice issues. And Juan Mendez, who I've had the pleasure of meeting recently, is a professor of human rights law in residence at the American University Washington College of Law. He's a native of Argentina. He has served as the UN Special Rapporteur on torture and other cruel, inhuman, and degrading treatment and punishment, and is a special advisor to the prosecutor of the International Criminal Court. He is also co-chair of the International Bar Association, Human Rights Institute, and president of the International Center for the Transactional Justice. He has served as a special advisor on the prevention of genocide to the Honorable Kofi Annan. And in the 70s, as a result of his involvement in the representation of political prisoners in Argentina, Mr. Mendez was arrested and subjected to torture and administrative detention for more than a year. So you can see today's presenters represent an esteemed group of people, specialists in this area, and we're proud and really very appreciative of your taking the time to participate with us. And we look forward to your leadership in the future to help guide us as we address these critical issues. So I'm going to turn this back over to Heather. And we'll go ahead and get started with today's presentations. Heather?
Yes, thank you so much, Jeff. I just wanted to share some information before we get started. Right now, everyone in the audience is on mute to avoid background noise. We ask that you please stay muted and leave your webcams off until the Q&A. We welcome you to introduce yourself and talk with other attendees and the organizers in the chat. You also can type any questions you have in the chat throughout the presentation. If your question is for a specific speaker, please type his or her name first. You will also have an opportunity to unmute yourself and ask your question during the Q&A at the end of the presentation. Okay, so our first presentation is from Dr. Kivlehan, and I will be playing that now. One moment, please.
Greetings, everyone, and welcome to you all. We're excited to have you join us for Module 1, the beginning of our 4-part series, Identifying and Responding to the Torture of Children. Module 1 is focused on the international legal framework for violence against children and includes 3 speakers. I'm Colleen Kivlehan, and I have no conflicts of interest. On the next slide, thank you. Next slide. We're going to start with a case study of Hassan. Hassan is a 17-year-old boy from Syria, and he presents to you with abdominal pain and urinary retention. He tells you about sexual abuse he had as a child and that his uncle was the perpetrator. And when he was 15 years old, he was captured at a checkpoint with his father, and he was detained in a local security branch. He's not seen his father since that time, and he assumes that he was killed. Hassan witnessed and heard the torture of other men while he was in detention. He also witnessed extreme sexual violence against others. While in detention, he himself faced forced nudity and was hit with sticks, as well as endured significant sexual humiliation and threats. Next slide. So how common is violence against children? What is the scope of that violence in our world? What we know is that about half of the world's 2 billion children experience violence at any single point in time. So the thing we're going to ask you to consider today with us is that children face violence at so many levels in their lives. It can occur at home, and we know that children can experience abuse at the hands of their caregivers in the home, including violent discipline. But it can also occur, as you know, at school with bullying and corporal punishment. And it occurs in their communities where children can be trafficked for labor and sexual exploitation, as well as police violence. In our world today, we know that there are millions of people on the move as a result of forced migration. Refugee and migrant children face continuous violence in their home countries, on their journeys, and in their future destinations. Next slide. So what do we know about the impact of the violence against children? We know a lot. We know that the impact is deeply significant. We know that the number of children, for example, living in war and conflict zones has increased dramatically and continues to grow. We know that armed conflict itself has a major impact on children's brains, on their learning and their behavior. And we know that the long-term impact of violence of all types has a significant impact on our cognitive, behavioral, physical, metabolic, neurologic, and immunologic development. And that can last for a lifetime. Next slide. So what do we do about this? As clinicians, it's really important that the first thing we know is that we understand what organizations across the world are doing about violence against children. It's also important for us to understand the definition of violence in the international context. In 1996, the World Health Organization, the WHO, defined violence as the intentional use of physical force or power against another person or group or community that results in injury, death, psychological harm, and other forms of deprivation. In 1989, the landmark convention that many of you have heard of, the UN Convention on the Rights of the Child, or the UNCRC, in Article 19 specifically defines violence as all forms of physical or mental violence, injury or abuse, negligent treatment or neglect, maltreatment or exploitation, including sexual violence, This wide definition of violence against children has been so helpful to us as clinicians as we think about our best options for preventing and mitigating the risks of violence. This definition supports us to step out of our narrow boundaries in our specialties about child abuse or conflict-related experience or torture, for example. Because for children, violence isn't divided into these silos. Violence is pain. Children don't think of it as child abuse or ill treatment or neglect or torture. Physical, psychological, and sexual violence shake their worlds. Children deserve to have us as clinicians help them without regard to our clinical specialty boundaries or expertise. Over the last several decades, we know that the definition of violence against children needs to be expanded even further than that described in these conventions and articles. It now needs to include the impact of climate change, of acute infections like COVID, and educational deprivation, things that are happening right now to our children across the world. On the next page, when we hear about the Convention for the Rights of Children, we remember, again, that this level of pain and violence shakes children and shakes their own boundaries in their lives. On the next page, we think, what is a convention? After all, is it a law? What is it? It's actually an agreement between countries to obey the same law. So they don't have these individual laws, it's their agreement. And when the government of a country ratifies or agrees to that convention, it means that they will obey that law that's written down in that convention. In the next slide, we can see the substance of the UN Convention for the Rights of Children. There are actually 41 articles or 41 paragraphs that detail a specific right for children. And they have in common some really important principles. And we're going to talk a lot more about these principles here in a second. Go ahead to the next slide. And here we are. The first is that these principles are applied to children without discrimination. So race and religion and gender identity, none of those have any relevance in the UN Convention. All children are impacted by these rights and have these rights. The second is that a primary consideration in the UNCRC is the best interests of the child. And my other colleagues today will be talking much more about this. But the best interests of the child is actually a fairly complex issue. And we're going to hear a lot more about that today and over the next few sessions. Another principle is that every child has the right to stay alive, to survive, and to develop on their own. And finally, and a critically important component of these articles is the right to participate in decisions and all matters that affect them. And I think so much of our young climate activists in this regard, their ability and right to participate in what's happening in their world and how it affects them is a core right that was given through this convention. On the next page. So back to the best interests of the child. I teased you with that concept of what does that really mean? And I'm sure that each of us has a sense on a personal and professional level what it means to be in the best interests of the child. The formal description, however, is really helpful. And that is that in all actions concerning children, all, whether undertaken by public or private institutions or schools or courts, administrative authorities or legislative bodies, the best interests of the child is the primary consideration for our action. This is so fundamentally different from our current reality, from my perspective, in most countries around the world, where children are seen as property, as dependents, as subjects, without the rights that are clearly articulated in this convention. Some specific rights that are really important to describe today are children's survival rights, for example, during COVID, and children who aren't getting vaccine, which are a majority of the children in the in the world. Children's right to life and their need to live with good nutrition, good shelter, and an adequate living standard, as well as access to medical care. Additional rights include the right to development. Let's go to the next slide. So survival rights, we've talked about nutrition and shelter. Next slide. Development rights, very, very interesting. The right to an education, the right to be able to play and play safely, and leisure activities, to cultural activities that mean something to them, for access to information about why things are being done, and their freedom of thought, consciousness, and religion. Their protection rights. Protection rights are critical. As we know, we safeguard them from abuse, neglect, and exploitation. We recognize that refugee children have very, very complex needs and rights. We safeguard children who've been put in the criminal justice system. We protect children around being forced to work or employed. And we protect those children who need rehabilitation or who've suffered exploitation from this abuse. And next, the right to participation, as we described, their freedom to express their own opinions, to say what matters to them, and to join associations and assemble and protest peacefully. We understand that these opportunities to participate in childhood opinions matter a lot to their futures. And specifically, Articles 19, 34, 37, and 39 describe these rights in detail of survival and development in every site where the child exists. So not just home, but school and community and government, etc. Protecting the children from physical and mental violence, intentional injury, as well as torture, and capital punishment and life in prison. These articles call out sexual exploitation specifically and sexual abuse, regardless of where it happens or who is the perpetrator. So it takes an incredibly broad perspective into what is violence against children. And it mandates for us as health professionals to think of the entire continuum of these potential abuses. On the next slide. So we have the opportunity to get trained in a trauma-informed care approach that recognizes and responds to the levels of trauma in the children who are in front of us. We can respond, we can learn to respond in ways that are open, collaborative, and non-judgmental. We have the opportunity to learn how we can respond to violence in ways that work and are legal in our own jurisdictions and within our own laws. It's important for clinicians to understand this, and most of the rest of this session is going to be about the legal framework of responding to violence. We have the opportunity to demand that mental health and behavioral health access is available to our children. And finally, we have the opportunity every time we're with a child or a youth to educate them about their rights, to promote their own self-confidence and empowerment for their future. On the next slide, I want to discuss this complex slide for a second. It's called the socio-ecological model of violence against children. And I'm sure many of you have seen similar approaches to thinking about the global nature of this crime. So this level reflects child maltreatment, child abuse, and domestic violence in the center, in that dark blue interpersonal bubble. Classic child maltreatment, child abuse in that setting. What happens at home for the most part. In the next bubble surrounding the interpersonal level is the community level, where children function every day. And that includes our schools or churches, for example, and can include things like corporal punishment or bullying. The next level where children face violence is at the society level. That's represented by inappropriate incarceration of children, for example, traditionally harmful cultural practices in some societies, child labor and trafficking. And finally, right now, especially at the front of all of our minds, is the trans-societal or global level of violence against children and their future. Things like the global struggle of climate change, armed conflict, globalization of our economy, and global migration. On the next slide, I want to bring us back to the story of Hassan, who suffered not only a difficult childhood with early childhood forced labor, reduced access to education, child sexual abuse, as well as ill treatment and torture as a teenager. He represents the many children who suffer not from a single trauma, not from a single bad event, but a constellation of traumas. I implore each of us to focus on a much wider definition of child violence as we meet together over the next 4 weeks, and really think about things we haven't considered fully in the past, the large impact that violence has on our own future and the future of our world. Children deserve our care in a comprehensive manner. It's time that as clinicians, we integrate the skills of those who are experts in child abuse and neglect with those who are experts in the documentation of ill treatment and torture, in conflict, in migration, those who are experts in food insecurity and climate change. This integrated approach can make a difference for our children. Next slide. At a bigger level, the UN describes 5 primary systemic interventions that they call international ingredients for success. And these include a strong legal and policy framework like the UN Convention for Children, reinforcing the local and national protective shields around kids, not just the global protective shields, but what are the things we can do at the local and national levels? Better research on both the epidemiology of violence as well as its impact. It's disturbing that we don't even know how many children are impacted, for example, by sexual abuse or sexual violence. We don't do research in this area that is comprehensive. A widening of the partnership in the global movement to end violence against children. This is connected. This is intersectional to all of the activity going on right now in COVID prevention and mitigation, in global climate change. And finally, a commitment to continuously listening to kids, amplifying the voice of the children as we work to make these 41 articles of the UNCRC a reality. Next slide. For me, an important guidepost is the 2030 Agenda for Sustainable Development. It's a really lofty document, but so are all agendas for development in our world. And in this document, it calls for the elimination of violence against children by 2030. That's in Target 16.2, if any of you want to look at this. It's incredibly lofty. I look at my watch and realize we only have 8 years to the end of violence against children. And what I'm confident about that is that we will make almost no progress by doing what we've done in the past. And that is working in our current silos. Children are at the intersection of every major problem our world is facing. I urge you to join us in exploring ways we can all make a difference for children across the world. My colleagues, Juan Mendez and Renata Winner, will teach us about the legal and reporting aspects of child violence. We will use this as our foundation as we move into the next two modules, which will focus on clinical aspects of child violence, and then moving into the final on action and reporting these events. I look forward to seeing you in our upcoming sessions. Thank you.
Okay, thank you so much, Colleen. Our next speaker will be Renate Winter. Justice Winter, if you could please unmute and turn on your webcam.
Is it okay? Can you hear me? Is it okay?
Yes, yes,
Okay,
thank you.
then let's start. I also do not have any special interests or problems. And I am a judge by profession, and therefore my part is a little legal and maybe also a little dry. I'm sorry, but we cannot avoid it if we would like to get all the informations we need. There are lots of international texts concerning children and violence against them. First, the Convention on the Rights of the Child. You have heard about it already now. Second, the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment, already from 1987. The UN Standard Minimum Rules for the treatment of prisoners, 2011, the Mandela Rules, and the Istanbul Convention 2014, which is just now updated and will be hopefully done with in 2022. I'm not going to speak about this convention because this is Juan who is doing it. Next one. What is the Convention on Torture giving us? First of all, the definition of torture, which is important in legal texts, because when, as a judge, I have to decide if torture has happened or not, I have to know exactly what it means. Second, we have the ban on torture. That means that everyone who is torturing is liable for it in all forms. That means if he does it, if he asks for it, if he tries to convince somebody to do it, and so on. So all forms, if he tries to do it, all forms of penal possibilities are covered with the ban. The ban of refoulement is especially important now in times of migration, because it means that no member state has the possibility or has the right to send a child that is into, or also an adult who is in danger to be tortured in his or her own country back to this country. The obligation to prosecute or extradite is a very specific legal provision, namely, if a member state hears or learns that something torture or mistreatment and so on has happened, this state has either to prosecute the accused person, or if it's not a member of this given state, to extradite him or her. But action has to happen. And it is also not only a ban on torture, but also a ban on cruel, inhuman, or degrading treatment. So you can see that the definitions in the different documents are more or less overlapping, because of course the facts are always the same. Next one. Yeah, I forgot to say that we have still quite a lot of other documents from the Council of Europe or the European Union. These are quite a lot of extra conventions, directives, and guidelines that we have to take into consideration as well. We have, when we speak about cruel, inhuman, or degrading treatment, then we speak, as has been mentioned already, for these things happening in the family, in the school, in institutions, especially in prisons, but also during sale, prostitution, and pornography concerning children. These are the special points where we have to look all the time. Mandela rules are the rules that speak about what is happening in the prison. First of all aspects of prison management, which is directed to the staff of a prison, and speaking about how the staff has to behave, what the staff is not allowed to do, and torture and degrading and inhuman treatment is forbidden. And then there is also the minimum standards for the treatment of prisoners direct, what a prisoner is entitled to have, what a prisoner is entitled not to bear. Next one. Next one, please. Yeah, the Istanbul Convention, as I said, I'm not going to speak about it because Juan is doing it. I'm just mentioning the 4 pillars that we can find: prevention, protection, prosecution, and integrated policies. And that means prevention, meaning also information, giving information to people. Protection means that laws have to be in place in order to be able to implement the protection of children, and not only children, of course. Prosecution, the same as I said before, either extradite or prosecute. And then finally, the last chapter, the integrated policies, how to come to this point of implementation. And finally, of course, the monitoring, how is the situation in a country and how should the situation be. Next one. We have heard about the Convention on the Rights of the Child already, but there are concerning mistreatment and torture, there are extra documents annexed to the convention as well. First, the UN Standard Minimum Rules for the Administration of Juvenile Justice, the so-called Beijing Rules, where we have also the administration, meaning of administration also of institutions. That means all institutions where children can be open, semi-open, or closed. Closed like a prison, semi-open like a boarding school, open like a daycare center. We have the UN rules of the protection of juveniles deprived of their liberty, the Havana rules. They are directly going to speak about the problem in closed situations, only in closed situations. And this is not only a prison. This can also be an asylum for, asylum now, a building for children with cognitive problems and so on. That can be a hospital, a closed hospital, or a closed institution for persons, for dangerous persons who have mental problems. All these closed institutions are addressed in those rules. Finally, we have the optional protocol to the Convention of the Rights of the Child #1, which deals with children in armed conflict. And I have had to deal with children in armed conflict as a judge in 2 countries, in Sierra Leone and in Kosovo. And you cannot imagine, if you have not seen it and heard from them and listened to them, what they had to endure for their whole life. And they're at a very young age. My youngest child soldier I had to deal with was 4 years old. He was smaller than the Kalashnikov he had to transport. And the optional protocol to the Convention on the Rights of the Child #2 on sale, prostitution, and pornography tries to protect those children that are trafficked throughout the world, and not only trafficked by institutions, trafficked very often by their own parents, sold by their own parents, and in every case misused, in each and every case. And we have millions of those children now. Next one. The Convention on the Rights of the Child, once again, I'm not going into the details, just to say that it applies to all persons aged 0 to 18. They are called minors, and 18 to 21, the young adults, in case they are not ready to be an adult already. Not ready does not mean that they are not humans. Very often children are regarded as humans in the making, but there are no humans in the making. There are humans with all human rights, and they are right holders and not objects to rights. They do not have to ask to have a right. They have a right, and they have all the rights that adults have, plus extra protection rights. That is the main issue for the Convention on the Rights of the Child. And it applies to all member states having ratified the convention. And this means, in this regard, it is the only one convention worldwide that has almost all member states of the UN. It's only one member state missing, and this is the US. All the other member states of the UN are also members of the Convention of the Rights of the Child, which means it is more or less globally ratified. Next one. When we speak about protection of children, then we have to find out how we are going to protect them. What is the Committee of the Rights of the Child, a treaty body, doing? A treaty body is an institution that is created by a convention that is ratified by a member state and by the United Nations. So a member state and the United Nations make a treaty, and the committee is the treaty body that checks what is happening in the member states, if the member states are doing what they have ratified, because it's easy to ratify that I am looking in the best interest of the child, but I'm not doing it. Because I have interests on my own, maybe as a judge, I am interested as a judge in the justice system and not in the child at the first place, and so on and so on. We have to check the report of states every 5 years. We have to find, and there are quite a lot of different states who react in a very different way. There are those who are honestly telling about what the situation of the children in their country is for all the questions that we are asking them. There are member states who are pretending that they are the best and everything is fantastic in their country, which from the very beginning is wrong, because there is no country where everything is wonderful, and especially not concerning children, because the needs of the children are evolving and are changing, and therefore one has to adapt all the time. There are countries that are in need because they do not have the possibilities, neither financial nor as experts, having experts to be able to implement what they want to implement. And finally, there are states that cannot do it because either their constitution or their customs or their traditions or their religion forbids it, or forbids several of the articles, to use the articles, several of the articles in the convention. We had not only checked the reports of the member states, but also the so-called shadow report. This is the report of the NGOs, the human rights institution, the ombudspersons, if there are, and reports of children who are writing to us to speak about the situation in their country. Finally, we invite the NGOs and the children. We are the only one treaty body, there are 10, that invites also children, because they are our stakeholders, to Geneva for a dialogue. At the moment, it's a bit difficult because of Corona. Sometimes we have to do it online, which is very, very difficult. This time, just in the moment, the committee is in session in Geneva. We are inviting then the member states to Geneva for a dialogue. And finally, we are writing our so-called concluding observations, where we ask the member states to make things better and tell them how to do that. Next one. These four articles you have, about these 4 articles you have heard already just before. I'm just trying to bring it in line with our subject, torture and mistreatment. Article 6, the right to life, survival and development. You can imagine that with torture, mistreatment and neglect or violence, there is maybe a right to life, but certainly, and even maybe survival, but development, how are you going to develop under situations of torture, mistreatment, neglect and violence? This is the problem of the pediatricians and the problem of the healthcare people. We, the justice people, we have to fix it to show if something has happened or not. But we cannot give the treatment answer that you can give in this regard. Article 2, the non-discrimination. There we have to distinguish between open discrimination. For instance, somebody is black, somebody is white. But there's also a hidden one. Do we really treat the sister the same way as the brother? Do we really treat the firstborn son similar to the second-born son? This is important very often because the treatment of children can be mistreatment or neglect. So do we not neglect the firstborn son, the heir, but the other ones, yes? This is an issue concerning hidden discrimination. Institutional discrimination is the one that happens in institutions by their structure. Like, for instance, I have in a school children of a minority and other children, and of course the children of a minority are treated not so well as the other ones, and so on. Best interest of the child, what are the problems? In the family, corporal punishment is best, maybe not even in the best interest of the family, even if they pretend that it is the case, but it is not. Child soldiers is a huge issue. How can anything concerning war be in the best interest of the child? Never, ever. And child labor, there we have a huge problem, also millions and millions of children in labor. And now with the problem of Corona, once again, we are back at least 5 steps in where we are, where we should have been, because very often parents who from the very beginning did not want their children to go to school now take them out, or they have been out because there was no school, and the parents have no wish whatsoever to send the children back to school. Same happens if the parents would like to, but cannot afford it because of Corona. So these are the problems that we have with child labor at the moment. And Article 12, of course, the right to be heard cannot work if Article 2, 3, and 6 are violated. It's not possible. We try to give the children a voice, but how are you going to have a voice if you say something and your father is beating you up? How can you open your mouth in a school when as soon as you are doing it, you are going to be punished? How can you do that in a prison where you end up in an isolation cell if ever you do something they do not want you to do? Next, please. Now, that one we have heard. We have heard already. Can I have the next one, please? Yeah, because now I'm coming to my own part, to the part of a judge. My job is, in cases of torture or mistreatment, to state if yes or no that has happened. What and I have now to discuss with you what are the conditions that I can do that correctly. What do I need from your side? First of all, I need the expertise by an expert, which means somebody who really is trained in seeing and defining torture or incorrect or mistreatment and so on, to be able to tell it to me. Second, I need the qualifications of experts determination. Do I have a CV of the expert? What is the content of the CV? Do I have the possibility to find out what exactly is the scope of the expert's knowledge? What is the exact field of knowledge? Is this a torture expert, or is this an expert on illnesses? Or is this an expert on sickness in prison, whatever? What is the exact field of knowledge? And finally, if the expertise is admissible. Most difficult issues, we come to the next slide, please. Admissibility is crucial for the justice system. Can I use the expertise or can I not? What are the conditions for being able to use expertise? First of all, as I said, I have to have an expert with sufficient knowledge and who is recognized as a witness by his or her peers. Second, the expert witness has to be recognized as credible. And this is what we call a so-called prima facie reliability on sources. What kind of sources has he cited? What kind of sources has he used? The third point is his or her testimony inference based on general knowledge and common sense? Is there something that is against general knowledge? Stupid example, you cannot break a bone. You can only bend a bone. No, that goes against general knowledge and against common sense. Has the testimony effects on the decision of the issue? It's the so-called ultima issue rule. If the expert tells me something that is not covering or not addressing torture or mistreatment, then all his expertise or testimony doesn't help me, because if he tells me that the prisoner had a wet clothes on and doesn't tell me why this wet clothes is in this regard or in this situation a mistreatment, then I cannot use it, because it does not make sense. And finally, and this is the most important point, there must be never an opinion on the criminal responsibility of the accused, because this is the work of the judge, not the work of an expert. And if an expert, please, next slide. If an expert comes up with saying, so this person, according to my testimony, this person is criminally liable, then I have immediately to exclude his or her expertise, because this statement cannot be made by an expert, can be made only by a judge, because it is not in the expertise of whatever expert. I have to exclude an opinion of matters not based on his or her own observation. Which means if the expert tells me, I have heard in prison that this and this is happening regularly, it doesn't help me. It helps me only if he says, I have heard it myself. For instance, or I am told that you can see on the skin of a person the marks of torture. It doesn't help me. It helps me only if he can say, I have seen those marks. As examples. It must be a clear description of physical situation. Clear means understandable and not in, how would I say, a professional, only professional language for doctors, but understandable for also non-medical people. I need the psychological impacts if there are. And once again, never a reference to the author of facts, unless you immediately you can prove you have seen Mr. X doing that to Mr. Y. That is the important situation. Next slide, please. Next slide. Yeah. So these are the conclusion of a judge that have to be that we have to follow. I have to speak about the determination on the weight that I give to the expertise. It's credible, it's not credible, it's completely credible, it is admissible, and so on. I have to find if this language that the person used is simple, and if I would be very grateful not to have a book, but to have an expertise of, I do not know, as long as it is, but not a book. I have to have a good reasoning to see that the expert's reasoning is covering the facts that he shows. And I have to make sure that the objective is covered. The expertise has shown that we have facts, and that these facts are the reason for the torture and for the impacts on the torture of a person, to a person. Okay, next one and last one. A very small story, because my time is over already, a very short story. In a country where there has been civil war, there was the end of the war, and there was disarmament, and all the children that were child soldiers have been disarmed, especially the boys. The girls have a special problem in this regard. And NGOs tried to find the families of the boys, to bring the boys back. At the same to the families. At the same time, a court made investigations to find out if crimes have happened and what kind of crimes, and therefore has sent investigators to speak with members of the population in villages, in cities, and so on. And one time, a father with his daughter came to his daughter and he himself were witness to the fact that the boy of the neighbors has cut off the hands of the girl on a gunpoint, forced by a rebel group that has entered the village. When the NGOs tried to find the families of the children, they found also the family of the boy. The family of the boy did not take the boy back because the village would have punished them, because this boy has committed a crime against a member of the village. The village itself and nobody in of the village wanted to take the boy back. And because they said this boy has nothing to do in our community anymore. And they said that he should go maybe to the capital and try to work there, which could not happen because the people of the village would not allow that because they feared that he would come back with criminals to maybe to do something wrong in the village again, to steal, to rob, to murder, whatever, because they were adamant that nobody would have this boy working for them at all. He would never find any work because of his past as child soldier. He only could work for criminals. So they did not know what to do with the boy. And then all of a sudden the boy said, I do know what I can do. I will marry the girl, because the father said he is not going to deal with the girl. He will chase the girl out of his family because she has no arms, therefore cannot work for a man, and therefore he cannot sell her into marriage. So the boy said, I am going to marry the girl, and everyone was happy. And somebody asked the girl, but oh, for God's sake, you do not want, have you asked the girl? You do not want that girl is going to live with that boy her whole life, the one who has cut off her hands? And then the boy spoke and said, you see, If my father kills me or my husband, it does not matter. I thank you for your attention.
Thank you so much, Justice Winter, for sharing that information and those insights with us. Our final speaker is Mr. Juan Mendez. So Juan, if you would like to share your webcam.
Thank you very much. I want to express my appreciation to IPSCAN, ISOP, the University of Florida Medical School, and the medical school at the University of California in San Francisco for the invitation to participate in this inaugural session of this important course. Like my predecessors, I also had occasions of heartbreaking scenes during the visits to countries that I made when I was the Special Rapporteur on Torture between 2010 and 2016. Those country visits are at the invitation of the country, obviously, and they are reflected later in a report that is submitted to the Human Rights Council of the United Nations. In every visit, the Special Rapporteur on Torture particularly needs to be able to visit detention centers of all sorts. And we always insisted in visiting at least one juvenile detention center. And that's how I got to see, for example, children chained to the floor or to the walls in privately run prayer and fasting centers in Ghana. And I also witnessed a child, maybe 12 years old, showing unmistakable signs of having been lashed with wire at a juvenile detention center in Morocco. But in addition to country visits, the special rapporteurs perform their work also by receiving complaints from the public and exchanging notes with governments, and then eventually publishing what we call observations reports. And I want to mention a couple of them to you. In one related to the Republic of Yemen, I wrote about the alleged execution of 2 minors and the imminent execution of 23 individuals reported to be minors at the time in which they had committed their offense. We argued that sentencing a person to death for having committed a crime when under 18 years old amounts to cruel, inhuman, and degrading treatment or punishment, and that there's an emerging norm of customary international law prohibiting the execution of children, even in countries that choose to retain the death penalty. And in another case, this one involving Nigeria, we commented on the allegations of torture and killing of children suspected of witchcraft in the state of called Akwa Ibom. And we referred to Human Rights Council Resolution 16/23 of 2011, saying that torture and cruel, inhuman, and degrading treatment is prohibited at any time and in any place whatsoever, and thus and therefore can never be justified. In my capacity as special rapporteur, I determined that the rights of these children under the UN Convention Against Torture had been violated, and I called on the government to ensure that all children are specifically protected against abuse. But country visits and observations reports, that is, exchange of notes under a complaint procedure, are 2 of the main methods by which special rapporteurs and working groups perform their mission. A third one is the opportunity to submit thematic reports to the General Assembly and to the Human Rights Council. That is basically 2 thematic reports each year in which we exercise the mandate. In 2015, I chose to dedicate my thematic report to a report on children deprived of their liberty from the perspective of the prohibition of torture and other ill treatment. And I explored the international legal framework, obviously, that has been mentioned already, to which, of course, the Convention on the Rights of the Child has made a major contribution in expanding and spelling out what the obligations of states are. And of course, complemented by the protocols and the 2 additional protocols, but also by the non-binding resolutions that Judge Winter mentioned as well. The prohibition of torture is absolute, not only for children, but for adults as well. But international law also acknowledges that in addition, children are entitled to special protections. Because of the unique vulnerability, the international law requires higher standards and broader safeguards to protect children deprived of liberty from being subjected to torture or other ill treatment, or from experiencing developmentally harmful and torturous condition of confinement. So beyond what international law requires in connection with adults. Because of these unique physiological and psychological needs, children in detention are at a heightened risk of violence and abuse, and they are more vulnerable than adults to be subjected to torture and ill treatment. In addition, they experience pain and suffering differently from adults, and therefore this calls on special measures by the state to prevent any form of pain and suffering that could result, that could be applied to children. There is therefore what we in international law call a heightened due diligence obligation to take additional measures to ensure children's human rights to life, to health, to dignity, to physical and mental integrity. The detention of children, whether within the criminal justice system or institutionalization or administrative immigration detention, is inextricably linked, if not in law, with ill treatment of children due to their unique vulnerability. Even very short periods of detention can undermine a child's psychological and physical well-being and compromise cognitive development. So that's why in my thematic report, I concluded on the basis, of course, of evolving standards that the international law was already embracing, that the deprivation of children, deprivation of liberty of children, is meant to be an ultima ratio measure to be used only for the shortest possible period of time, only if it is in the best interest of the child, and limited to exceptional cases. Abuses suffered by children outside the criminal justice setting, for instance, by children in healthcare or social care institutions, such as orphanages, can sometimes be the result of acts of omission rather than commission by a state agent. For example, emotional disengagement or unsanitary or unsafe conditions that can result from poor policies rather than from an intention to inflict suffering. In this context, it is important to recall that purely negligent conduct may certainly constitute ill treatment if it leads to pain and suffering of some severity, and when the state is or should be aware of the suffering, including when no appropriate treatment was offered, or when the state failed to take all reasonable steps to protect children's physical and mental integrity. So the state's obligations to prevent torture applies not only to public officials, but also to medical doctors, healthcare professionals, social workers, including those working in private hospitals, child care institutions, and detention centers. Detention can certainly exacerbate a child's already heightened emotionality and limited capacity to self-regulate, especially in adolescence. Proper training of custodians to de-escalate and manage behavioral issues is therefore essential to avoid the use of physical force or unnecessarily resourcing to law enforcement. While in detention, children can be subjected to a range of adult punishments, including physical and manual restraints, routine humiliation and degrading searches, and indiscriminate use of harmful chemicals like mace, pepper spray, etc. During my country visits, I also observed the use of psychotropic drugs for children in detention in order to maintain security in juvenile detention facilities. In some instances, such forms of punishment or restraint are used as a first resort rather than in exceptional cases. In other thematic reports, I dealt with solitary confinement as a phenomenon that under certain circumstances violates the prohibition on torture and ill treatment. And that resulted in the Nelson Mandela rules that Judge Winter mentioned. The Nelson Mandela rules, as the new name of the UN Standard Minimum Rules on the Treatment of Prisoners, now include, after 2015, include regulation of solitary confinement, and particularly to prohibit prolonged or indefinite solitary confinement. But in addition, and following the literature, the medical and psychiatric literature, the Nelson Mandela rules now prohibit solitary confinement of children, even of any duration, not only if they exceed 15 days or is prolonged. So in addition, I wrote also my final report to the General Assembly was on the need for a protocol to interrogate persons in the criminal justice system and other fact-finding and investigative settings like intelligence or immigration, etc. As a result of that report, we spent the last 4 years with many experts from different disciplines drafting what we now call the Principles on Effective Interviewing in Investigations and Other Information Gathering. And the principles, the document has a special chapter dedicated to vulnerabilities, with an emphasis, of course, on children and how interviewing and questioning of children, whether they may be suspected of having committed a crime or they are witnesses or victims of the crime, requires some special rules and special principles that to be applied in those contexts. An essential safeguard against torture and other ill treatment is the availability of multidisciplinary and qualified staff working in children's institutions who are adequately trained to deal with children. In addition, children deprived of their liberty, as well as their parents or legal representatives, should have avenues of complaint open to them with the establishment's authorities, and those complaint procedures have to be effective. They have to have an independent mechanism to monitor human rights violations committed in the detention, in the juvenile detention center. As reiterated by the UN Committee on the Rights of the Child that Judge Winter just made reference to, visits must be regular and unannounced, and a special emphasis should be placed on holding confidential conversations with the children. The designated independent monitoring body should also have authority to receive and act on complaints to assess whether establishments are operating in accordance with the requirements of national and international standards, and to make recommendations regarding the need for changes in policy, practice, and legislation. As a result of the report on children in custody that I mentioned a few minutes ago, we also published in my law school a publication with the contributions by many professionals and experts on children's rights, and that had participated in the consultation that I conducted before writing my report to the United Nations. And that volume that was published in 2017 is called Protecting Children Against Torture in Detention, Global Solutions for a Global Problem. And it includes, as I say, essays from a variety of stakeholders and thought leaders reflecting the myriad issues that I raised in my thematic report. The issues that are addressed, just to enunciate them briefly, is first translating standards into practice, providing access to justice for children, the deprivation of liberty of children in conflict with the law in juvenile and criminal justice system, the placement of children in solitary confinement, the situation of migrant, asylum-seeking, and refugee children, and their deprivation of liberty. And the volume also examines the situation of children with disabilities in institutions and orphanages, as well as the situation of children in armed conflict and the detention of children on grounds of national security. On the issue of reporting, this publication discusses, it's an article by Dr. Hiranti Wijamane that elaborates on the article titled Protecting the Rights of Children Deprived of Liberty, that there's a lack of power, capacity, and opportunity for children to independently report offenses committed against them. In that same volume, Marta Santos Pais and Anne-Christine Verwig further elaborate in an article called Normative Developments and Legal Frameworks, the United Nations Model Strategies and Practical Measures on the Elimination of Violence Against Children in the field of crime prevention and criminal justice. That, end of quote, a long title. And they report that counseling, reporting, and complaint mechanisms are often
Oh, Juan, excuse me. I'm so sorry. Your mute button got pushed. Can you please unmute?
Thank you for warning me. I'm sorry about that.
No, it's okay. Thank you.
I want to mention the Istanbul Protocol of 1999 that was mentioned also by my predecessors. It's a manual directed to mostly to medical and psychological psychology professionals, and it's a manual on how to detect, monitor, and document torture. This protocol has been around, as I say, for a little over 20 years, and it's pretty well known to forensic doctors and psychologists. But it's very important that it be applied also by any health professional that comes in contact with people who may have suffered torture or ill treatment of any sort. And in a thematic report that I wrote, another thematic report to the Human Rights Council, I insisted on the importance of forensic medicine to detect torture and to prevent it as well. The reason I wrote that thematic report on forensics and torture and torture prevention was that in my experience, very few people, very few countries around the world really applied the Istanbul Protocol. Even specialized forensic doctors sometimes didn't even know about the protocol, or they knew that it existed, but they did not apply it on a daily basis. And in the opposite side of the spectrum, there were states where the Istanbul Protocol was very well known and discussed, but in the main, it was applied with the wrong attitude and approach, because it was it was applied in a way to show that torture had not happened, because a doctor had not been able to find a sign, a physical sign that torture had happened. And you can imagine the consequences of that for example, the admissibility of evidence obtained under torture. If the person cannot prove that the statement or declaration against interest was made under torture, then the evidence is admitted in court. So for those reasons, and also because of the time lapse and the advances of science, I called for a review. And after quite a bit of discussion, a review of the Istanbul Protocol has taken place, mostly under the leadership of Physicians for Human Rights, but also the International Resource Center for Victims of Torture. I had the honor of participating in at least the legal part of the revision. And so the Office of the High Commissioner for Human Rights, after commenting and editing the expert-driven draft, has also already announced that it will publish in this first quarter of this year the Istanbul Protocol. That is not meant to replace the previous protocol, but to expand on it and to benefit from the experience of 20 years and the advances of science in this. All children, in connection with this, I wrote that all children are to be properly interviewed and physically examined by a medical doctor or qualified nurse, reporting to a doctor as soon as possible after their admission to an institution. The new protocol has quite a bit of material on detecting mistreatment on children. And I want to mention just very briefly that in the chapter on relevant international legal norms and standards, there's now information on the legal standards applicable to children. And we expand a little bit and comment on the work of the Committee on the Rights of the Child, including its general comments on corporal punishment, juvenile justice, treatment of unaccompanied and separated children outside their country of origin, etc. Chapter 2 on relevant ethical codes establishes clearly that organizations have a duty of care to children, and it underscores that when clinical evaluations for torture are being conducted, children should be informed as fully as possible in a way that they can understand and adjust the communications to their age and development. In chapter 3 on legal investigation of torture, the new protocol stresses that when selecting an investigator, children who may have been traumatized by torture should not be isolated from positive and supportive adult contact, and the child's well-being and best interest of the child must be paramount at all times. There's a chapter on general considerations for interviews that has an entire section on interviewing children. For lack of time, I won't go into the details here. And then on the chapter on physical evidence of torture also has a section that solely focuses on children. And the chapter on psychological evidence of torture and ill-treatment includes factors to consider when interviewing a child for the psychological effects of whatever mistreatment he or she has endured. And it includes development considerations, considerations for conducting the evaluation, clinical considerations, and diagnostic classifications, as well as the family context that needs to be taken into consideration as well. So, and also the new protocol has a full annex separate from the text of the protocol on guidelines for documented torture and ill treatment of children. Again, for lack of time, I'm not going to go into the details that are included there, but I recommend to you this soon to be published document, because in my mind, it includes quite successfully the state of the science and the state of the law with regards to torture and ill treatment of children, and how to prevent it, how to document it, and how to counter it, counter its effects. So with that, I'd like to conclude, and I'm sorry if I've taken more time than I should have. Thanks very much.
Thank you so much, Mr. Mendez. Renate and Colleen, if you're able to turn on your cameras now. And I'll turn it over to Jeff to open the Q&A. Oh, you're muted, Jeff. Oh, that you're good.
Well, first of all, let me thank the three of you for an astounding presentations and the information you provided. As I said from the beginning, this is not about turning us into experts, but really giving us a background that we can build on. We're relatively short on time. We've collated some of the questions, and we'll go back through the questions that people have put in the chat and pose those perhaps at a later time and be able to respond to them. All of the information that's been provided will be up on a website, and we'll be getting that information to you. And Heather will give us information on how people can apply for CME credits. I just want to start off with two questions. The first is, and Renate, maybe you can take a stab at this one, so to speak. You put up in your slides all of the requirements for individuals to be experts. If I'm a clinician who's working in a refugee camp or working on the border or wherever, and I notice patterns that seem to me to be a result of torture, and I come to you as an expert witness. Will I be an expert witness if I don't have an extensive background and experience in these arenas?
Once again, Jeff, it depends on what expertise is asked. If the expertise is asked with your with what you know, with your knowledge, then I can accept it. I mean, speaking now as a judge, so to say, I can accept it. For instance, you are trained in finding torture signs, but you are not trained in finding mistreatment. So if this is the case and I am dealing with torture at the moment, then I can accept you. If I have to deal with mistreatment and this is not your part of expertise, I cannot. So the definition of your expertise is important. What can you show me that you are an expert on X, Y, or Z? Your CV, your university experience, your experience as a professor, your experience as a rapporteur, whatever, what you have. And then I can make the decision if I can use it or not.
Well, thank you. And if to both Renate and Juan, how do we make a report? So, you know, the seminar series is really to focus on medical professionals who are in the field working. And if I were that person and I noted a pattern that seemed to me to represent torture, who do I go to, and how do I get my voice heard?
Juan, you start?
Yeah, by all means. Thank you. Well, if you're talking about making a report to the international mechanisms of protection, there are some variations, but you should know first of all that the formalities are not that that serious, that complicated. For example, to the Special Rapporteur on Torture, you can just write a note. If you ask the UN Office of the High Commissioner, they can give you a form, but all special rapporteurs and working groups, and especially the Special Rapporteur on Torture, will accept information coming from the public in any manner that it comes. Obviously, the more detailed, precise, specific that you are on it, the better. With respect to treaty bodies like the Committee Against Torture, you can only submit complaints against states that have separately accepted the jurisdiction of the committee to receive complaints, and that applies also to the Committee on the Rights of the Child. So you have to check first whether the state where the events occurred or that is responsible for the event falls in that category or not. But it would, even for countries other than those, since they may be signatories to the Convention Against Torture, but not accepted the jurisdiction for individual cases, you can still submit material, mostly through the Office of the High Commissioner, directly to the treaty body, because they can be brought up in the context of what is called periodic review of the behavior of the state with respect to its obligations under the convention. And then there are regional bodies as well. In Africa, Europe, and in the Western Hemisphere, in the Organization of American States, there are judicial and quasi-judicial ways of filing information that then is acted upon. Obviously, acted upon means that you need to do some follow-up as well, because you can imagine all of these organs have a flood, literally, of complaints, and it's important to find out, for each of those regional systems at least, what are the minimum tests that you have to comply with before submitting a complaint. For example, have you exhausted domestic remedies, or is this a case where there is a waiver of the exhaustion of domestic remedies? And there, of course, there are many international human rights organizations that have people who are very well versed on how to submit these complaints.
Yeah, and if you speak about domestic issues in countries where the justice system works, because there are a lot of countries where it doesn't, but where the justice system works, you first of all go to your own police or prosecutor. In cases where you can, as I said, where you can do something. It does not work in countries where the prosecution and the police works in the interest of the government and will do everything they can not to acknowledge that torture or mistreatment has happened. But it depends on the states, as I said. And as Juan said, in concerning most international courts, first of all, you have to try to find out if there's a national possibility. And only then you can address, unless there is urgency, of course, and only then you can address the international legal institutions. Thank you.
Thank you. If it's okay with the speakers, we're just going to continue on a bit, since we did have a number of people who submitted questions. Heather, do you want people can raise their hand, or how do you want that to work?
Yes, I think that would be best. So in your toolbar at the bottom of your screen, there's a reactions button where you can find the raise hand icon. If you have a question that you'd like to ask, please click on that and we will call on you. I see a couple people already have their hands up. So Wajahat Ali, if you would like to ask your question, please.
Yeah, thank you very much. My question is from Renate Winter. She, in her talk, she told about international laws about the juvenile justice system and other international guidelines which apply on those children who commit criminal offenses. She's the judge of the court, and she talked about the criminal responsibility. I just want to know that what is the minimum age of criminal responsibility that you follow in your cases while making the adjudication in cases where children are offenders? And what is the internationally accepted level of age of criminal responsibility in juvenile cases where the juvenile commit criminal offenses? And the other thing is, you mentioned that while determining the criminal responsibility, you don't give preference to the opinion of expert witness. You prefer your own, your own judgment to determine the criminal responsibility of the accused child person. While in other countries, like in Canada or in other developed countries, while determining the criminal responsibility in juvenile offender cases, courts normally call the expert witness and give preference to the opinion of expert witness. Like court can call the forensic psychiatrist to determine the criminal responsibility of any particular person. And the opinion of forensic psychiatrists.
Can we limit the question? We have a number of people who are
And I
interested in
understood-
asking questions.
I understood already. I think I can answer. First,
Okay.
the convention, the Committee on the Rights of the Child, in its one of its general comments, has asked for the criminal responsibility of children aged 14. Age 14. In any case, it should not be lower than age 14. The convention itself doesn't speak about it, only says that it is important that it is not too low. But the opinion of the committee is 14, sorry. The point is concerning expert witness, I am never not preferring expert witnesses, but we did not speak about child offenders. I spoke about adult torturers and not child offenders. In case I do not know the age of a child, like for instance, in cases of child soldiers, then I have to have an expert, and this is a forensic expert or a psychologist, in most of the cases, a team who can tell me if a child is over 14 or under 14, over 18 or under 18. Thank you.
Okay, thanks.
Okay, thank you, Wajahat, for that question. Linda, would you like to ask your question?
Yes, thank you. I'll ask it to Juan Mendez if I can. I'm work with Jean Sarson, and we've been working with women who've been tortured in their families from the time they were children, but not in detention. And they're from all over the world, and they're the same tortures that they endure in detention: electric shocking, drugging, water torture. So what can we do to expand the knowledge of the health professionals to understand that children in their own community could be enduring torture, not even thinking that it could be torture, and also that parents traffic their children and that they're involved in pornography, which all include torture, non-state torture? Thank you.
Well, the the Convention Against Torture requires for the matter of state responsibility under international law that the torture be committed or tolerated, acquiesced in by a state official. However, precisely because it's not only the main actor, but it could be a state actor that looks the other way, the jurisprudence of several different organs in international law has been evolving. And for example, the Inter-American Court on Human Rights has said that at least under the Inter-American Convention on Torture, the torture committed by a non-state actor can still involve the responsibility of the state in cases in which a state knew or ought to have known that the person, the vulnerable person, child or a spouse in a domestic setting was under threat, under risk of being tortured, and did not do what was reasonable to protect the person. And there's some cases already decided by the Inter-American Commission and by the Inter-American Court. I think that standard of due diligence guides the international responsibility of the state for turning a blind eye to the kind of violence and torture that happens in non-custodial or even in private settings. And by the way, the definition of torture requires pain and suffering of a certain severity committed, and that pain and suffering can be either mental or physical, and it is not restricted to custodial settings. So just as we extend the responsibility of state for actions of state actors, for example, in excessive use of force in repressing demonstrations, we also extend, I mean, not we, the international human rights law in its present state extends the responsibility of the state, at least to the cases in which due diligence to protect people from torture under any setting, including the private domestic setting, due diligence is not exercised.
Okay, thank you so much, Juan and Linda, for your question. Jeff, I know Renate needs to leave soon. Do you want to say a few words to wrap up?
Yes, very much so. First of all, again, I want to thank the speakers for a tremendous introduction to these issues, which are complex. As I previously mentioned, we will for sure post all of the presentations, the slides, and also post as much as we can answers to the questions that people have asked. I want to invite folks to, for sure, also participate in the next 3 seminars, which will hopefully then end with a strategic approach to how we want to move forward as a global community of child advocates in addressing these issues. Let me just finish up by asking Colleen, Renate, and Juan if they have any final statements. Colleen, anything you want to add?
It gives me hope that all of you are there and from around the world to have this discussion. And so I'm really hopeful for the next 3 sessions that we can break some boundaries around our professional silos and look at our opportunities together. Thanks.
Renate, any final comments?
Yeah, in case that the mindset of people does not change, no law would help to prevent torture and mistreatment. It has the mindset in the heads of people have to change. And how to do that is, I do not know. I am not optimistic at all, but hope dies last.
Juan, hopefully you can end with a little bit of optimism.
Well, first, the optimism is that we have a very sophisticated, very detailed normative framework to define what we mean by violence against children and in different settings, and also to explore avenues of redress for children and of prevention for future violations as well. But Renata is quite right that the framework by itself doesn't solve the problem. And I am optimistic that the more that we exchange views and information about what can be done, the more that we can at least start making a dent on the on the existence of violence and violations against children. And in the progress will be with ups with starts and drawbacks, but it still will be progress, I think. And it will also happen in uneven ways in different parts of the world, but we ought to keep our eyes on the prize, as it were, and make sure that we care for the welfare of children in every setting, in every country, and in every region of the world.
Thank you very much. We will get out the information to you as far as CME credits. Please allow me to invite you again to the next several sessions. And thank you all for your commitment and advocacy on behalf of children. Thank you.
Thank you so much, Jeff. And I just wanted to finish by again mentioning the upcoming modules. You can see here, the next one is February 8th, Documentation of Violence and Torture, Basics and Best Practices, followed by Module 3 on February 15th, Displaced Children in Violence, Responding to the Effects on Mental Health. And our final one on February 22nd will be a special panel discussion on advocating against the cruel, inhuman, and demeaning violence and torture against children. You can learn more about all of these and sign up at ispcan.org. And I would like to conclude my part by encouraging you to become a member of ISPCAN if you're not already, so that we can continue having trainings like this in the future. Our member benefits include a subscription to our journal, Child Abuse and Neglect, a variety of other online educational resources, and discounts to our congresses and trainings, including our upcoming virtual Quebec City Congress, March 28th to the 30th. And also wanted to let you know that abstracts are open for our Estonia Congress, which will be June 13th to the 16th, hopefully partially in person. It will be a hybrid Congress. And we offer several membership levels, including our associate membership for just $35 a year. And finally, if you have any questions or comments about today's training, please reach out to us at resources@ispcan.org. As Jeff said, we will be sending a follow-up email with information on CME credits, certificates of attendance, and completing an evaluation form. Thank you all again so much for joining us today. Stay safe and have a great day or night wherever you are. Thanks so much.
Thanks.
You.
Thanks, Heather.
Thanks, everyone.
Thanks,
Thank you.
Heather. Bye-bye.
Thank you. Bye-bye.